everybody. Oh my God. You guys, I am in the best mood ever. You know why? Because Turtleboy told me last night that dicks are for dudes. Let's start this motherfucking day right, bitches. Good morning. It's Wednesday, Hump Wednesday. You guys, I was rolling last night. Turtleboy, thank you so much. You guys, he went off on somebody in chat, but the person he went off on in chat was actually like defending him and telling Karen Reed to shut up. I have to play this part of the show last night because I am rolling in bed. Wakes me up. Like, you know, you're just like, oh, I'll be restless. And let me just like, dude, no. God, it was fucking so good. So I want to start my day off like my night ended. But new merch for everybody. Okay. Dicks are for dudes, man. All right. Oh, shit. Lana, I sent the CW. Yes, I got that. We're going to be talking about Karen Reed. And obviously we knew that Bev was going to come through with this big fat denial. Oh, God, here's Busty D. Busty, you must have me on fucking alert, and I love it. Alert this hoe. Busty D says guilty. So we're going to go through, though, this document on how Bev's, it's like seeing it through Bev's eyes. But first, I want to show everybody why I was so, like, laughing my ass off last night. Turtleboy goes on a little rant. It was great. And then he's like, oh, I apologize. Bring her back into the chat. The title of the live is Karen Reed Case, Time to Fuck. I'm sorry, but this is just the best shit I've ever seen in my life. Time to fuck. Did you guys see that last night? Come on, take a look.
You up. Pull up, bitch.
Pull up, bitch.
I will fuck you up. I will beat your ass. I will fuck you up.
Objection.
Here we just added the lawyer who was a juror, a junior.
Heyo, bang bang. I will fuck you up. You're a bitch, bro. I will fuck you up.
Okay, so check this out.
I will beat your ass.
Okay, so it was right before here we go. Watch this. I think this is like the right.
To edit it as they want, cut it out there, whatever. That's how they fucking put it together, and I get fucked. And I get made to look like a schmuck. You know what I mean? So yeah, there it is. And again, okay, this person, ban them. You don't fucking tell me to shut the fuck up, Deborah. I say whatever the fuck I want on this show, and you sit there and you fucking swallow it. And then you give me a fucking turtle chat. And then you can fucking talk. Okay? Ban her. She's fucking done. Done. I will have no tolerance for that whatsoever. I say whatever the fuck I want. I'm not here to suck Karen Reed's dick. That is not what I do. Okay? I keep it real. The fact of the matter is, I'm 100% pro Karen Reed, whatever. That fucking thing was a disaster. A fucking disaster. And I think she would admit that too.
Yeah. Hold on. One more time for the cheap seats. I couldn't breathe.
A lot of private discussions with him, and I know that she means that, right? But the problem is when you go on camera and you give these people the ability and the freedom to edit it as they want, cut it out there, whatever. That's how they fucking put it together, and I get fucked, and I get made to look like a schmuck. You know what I mean? Right. So yeah, there it is. And again, okay, this person, ban them. You don't fucking tell me to shut the fuck up, Deborah. I say whatever the fuck I want on this show, and you sit there and you fucking swallow it. And then you give me a fucking turtle chat. And then you can fucking talk. Okay? Banner, she's fucking done. Done. I will have no tolerance for that whatsoever. Don't talk about this. I say whatever the fuck I want. I'm not here to suck Karen Reed's dick. That is not what I do. Okay? I keep it real.
Dick. Oh fuck shit. Then I'm like, this is great. I just literally turned on like 2 minutes before this, like right, and I'm like, oh my god, this is great. Then he's like, oh, I think we made a mistake here. Watch this.
The fact of the matter is, I'm 100% pro Karen Reed, whatever. That fucking thing was a disaster. A fucking disaster. And I think she would admit that too. You know, I think she would admit that too. Oh, okay. She's telling Karen to shut up. All right. That's different. No. But anyway, it has to be fucking said. You don't come on here and tell me to shut up. If she's telling Karen to shut up, that's different. But
it's fine.
Anyway, learn to use commas. I don't know.
Learn to use commas. Learn to use commas. Then, God damn it, Deborah. You guys, this is just great. This is. Oh God, I want learn how to use commas. My next T-shirt, man.
To edit it as they want, cut it out there, whatever. That's how they fucking put it together, and I get fucked, and I get made to look like a schmuck. You know what I mean? So yeah, there it is.
Thank you,
and again,
Sherry.
okay, this person, ban them. You don't fucking tell me to shut the fuck up, Deborah. I say whatever the fuck I want on this show, and you sit there and you fucking swallow it. And
you swallow it, Deborah. But look, and it says AK is for you, Karen. Shut up. Like, she's telling Karen Reed to shut up, okay? He's like, use commas. There's no commas in this one.
And then you give me a fucking turtle chat. And then you can fucking talk. Okay? Banner, she's fucking done. Done. I will have no tolerance for that whatsoever. Don't talk about this. I say whatever the fuck I want. I'm not here to suck Karen Reed's dick. That is not what I do. Okay? I keep it real. The fact of the matter is, I'm 100% pro Karen Reed, whatever. That fucking thing was a disaster. A fucking disaster. And I think she would admit that too.
I think she would.
You know, I think she would admit that too.
Now watch this. Watch this.
Oh, okay, she's telling Karen to shut up. All right, that's different. No, but anyway, it has to be fucking said. You don't come on here and tell me to shut up. If she's telling Karen to shut up, that's different. But anyway, learn to use commas. Then I don't know.
You guys.
Anyway, I apologize. Yeah, Jody's unblocked. We unblocked Jody.
Jody's unblocked. Bring your ass
anyway,
back.
she's telling. Okay, reverse the ban if we can. Sorry. I promise there are comment. Okay, if there is, there is.
I promise you. Now there was not a comma though. But I love it. He's like, reverse the ban, bring her back. Like, love it, love it. People that say Turtleboy is like, dude, he corrected this in a matter of seconds, minutes. You know what I mean? God, it was so fucking hot. Oh, God, it was so funny. You know, because you get to watch it and it's not edited. It's literally all happening in real time. I mean, the wit, you know. I think I'm a pretty witty bitch and witty titty. This had me dead last night. Woke my ass up. Look,
there is.
If there's comments,
I
there's
just
comments.
got noticed that the buffer zone has been extended.
There you go.
Okay, I can't wait to read.
So then we got to go talk about the Buffa zone. But anyways, that's how my night ended last night, and I was like, "Damn, you guys gotta hear this. This is priceless. You will sit there and you will swallow it. I'm not here to suck Karen Reed's dick." And then he starts talking about dicks are for dudes and, you know, but not to play with. I don't know. And then I was like, can we get some new merch over there? Dicks are for dudes, man. Dead, man. Damn it, Deborah. Deborah's over here like, I'm Blacko. All right. So anyways, that's how I wanted to start off my day today. So hashtag dicks are for dudes. Yeah, if you wear one, that's a different story or something like that. All right. So, all right, Turtleboy. So there you go. It was really something special over there. So we're all here because Karen Reed making moves here. The Buffa zone. Yep. That's going to be interesting. Not like you could see anything coming from the court. You know what I mean? Like we're just partying down a little, just a little lower, or a little up, whatever you want to call it. But the party is still going to continue on over there. So this Buffa zone means dick. Yeah. Yep. That's what I said, Murphy. I was like, Murphy, this is just great. This is just priceless morning. But hold on one second. Let me see. Karen Reed's got a new attorney. And rumor has it, Victoria B. George. Wow. Rumor has it that Victoria B. George was a juror on the last trial. And so she has Yannetti Criminal Defense Law Firm as the address, but I'm sure that's not it. Alan Jackson doesn't even, they're probably just all under his, but Robert Alessi has his New York, 1251 Avenue of the Americas, New York, New York. But Victoria B. George. So she's added to the ticket. Allegedly, she's the juror, a juror from the first trial. She was a dismissed juror. Oh shit! Don't even tell me she was the one that was drinking over there at the VFW we're about to get into. Oh no, I think it's great. Hell yeah! If this is not becoming literally O.J. Simpson 2.0, I don't know what is. Hold on one second. I have to take this call. Okay, sorry about that. I had to take a phone call. This should make Hank insane, right? I just think this is crazy. Woo! Victoria feels some type of way. She's like, let me join your ticket. All right, so here we go. Let's talk about it. On June 9, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of murder in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of a personal injury and death following the death of her boyfriend, John O'Keefe. Trial on the matter began April of 2024 and concluded on July 1st, 2024 with a mistrial. The matter is set for retrial April of 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary governmental misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon. So because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. So basically what they're also saying there with that is that, let's say if she would have been found guilty, she would have been getting a retrial. So how about that? Does everybody understand that? I said that she would have been found guilty. She would be getting a retry. That would be grounds for a new trial. And that's basically what she's getting. So Yeah. So that's how I took it. I'll say that she was found guilty. She'd be getting a new trial. Now, this is what she writes as the discussion to this. So, we're going to start here. The defendant argues that the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. As discussed below, the defendant has not demonstrated that she suffered any prejudice as a result of discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless. Okay, so it's really important to understand that had Karen Reed been found guilty, this would have all gotten her a new trial. That's a really important part of it, because case law then down in the future, when somebody would try to use Karen Reed's case law, it wouldn't be used in terms of, see, this judge didn't say that it should be, blah, blah, blah. So, Silent G, if you want to be part of the community here, these comments, okay? Just so you know. Marky, I handled it. So the defendant here argues, discovery obligations. This is the Karen Reed case. Silent G. I have so many lives about the Idaho 4 case. Bring it on up that way, or you can go ahead and email me. So A is the due process clauses of the federal Constitution of the of the Massachusetts Declaration of Rights require the Commonwealth disclose to defendant material exculpatory evidence in its possession and control. Now, I'm not going to sit here and read the case law, okay? I'm sitting here and I'm reading to everybody the what pertains to this case. And this would be B, which is now the factual background of this alleged discovery violation. So, on January 29, 2022, after O'Keefe was found dead in the snow outside the Albert residence in Canton, Massachusetts, police towed the defendant's vehicle to the Canton Police Department. Now, it's important to understand that what Bev said here is the following facts are taken from the parties' oral and written submissions, accompanying exhibits, and the court docket. Unless otherwise indicated, the facts stated are not in dispute. Any description of surveillance footage is based on the court's review of the footage, not the parties' descriptions. Okay. So this is how Bev sees it when she says factual background. She threw up a footnote. Okay. There were multiple surveillance cameras in use. There we go. Lana clearing throat, annoying. No, Mandy, you need to rewind the show. I don't have a voice right now because I lost it due to Turtleboy. Telling people to swallow his fodder. and that he's not here to suck Karen Reed's dick. You hear me? He is not here to suck Karen Reed's dick. God bless America. God, I hope he puts that little quote on one of his new trailers. All right. Because it is fucking tits. All right. Dicks are for dudes. Unless you're going to play with them. You are going to swallow it. So good. Swallow my fodder. Yeah, rewind. It's so good. It's so good. All right, here we go. Now remember, the murder weapon is allegedly the car, right? So there were multiple surveillance cameras in use at the CPD that captures the defendant's vehicle on a flatbed tow truck as it entered the sallyport at approximately 5:30 p.m. There were also cameras inside the garage where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from these cameras is automatically overridden on a regular basis. Footage from the night in question was not lost, however, because CPD Sergeant DeGambitro followed his customary practice of downloading the recording to a hard drive in 6-hour segments. Okay. On February 2nd, 2022, the defendant was charged with manslaughter. So just a couple days later, motor vehicle homicide, and leaving the scene of a personal injury and death in Stoughton District Court. That day, the defendant filed an emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. That was a preservation order. Now, what's interesting is that the preservation order sought to preserve the following: all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. And this is how Deb gets around this. I mean, Bev, fucking Deb, Jesus. This is how Bev gets around this. So based off of that description, the CPD cameras are not part of that. Okay. So the lead investigator in the matter, Massachusetts State Police Trooper Michael Proctor, she clearly wrote this before he was fired, took possession of requested CPD video of the sallyport in February of 2022, but did not turn it over to the prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file. My question is for all you lawyers out there, how could it still be to this day that this is unclear on the record? And that needs to be cleared up, wouldn't you think? So that's why that's underlined. So on June 9th, 2022, a Norfolk County grand jury indicted the defendant. This is when she was rearrested, because now she's being charged with murder in the second degree. Manslaughter. Well, so she has all these charges because they added murder. Now, on October 5th, 2022, this court issued an order directing the Commonwealth to provide the defense with all crime scene photographs and or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview, and February 4, 2022, including the metadata associated with these photographs and videos. Well, we know, you guys do know that there is no metadata that exists with this. Metadata, like what's that? Okay. Several months later, so those of you guys that are new to the case and wanted to catch up on the case, is a really good way to do it, is through a motion to dismiss. So several months later, in June of 2023, Proctor asked Canton Police Department whether it had in its possession any exterior sallyport video showing the defendant's vehicle on the flatbed of the tow truck on January 29, 2022. Then here Bev says, it is unclear to the court why Trooper Proctor requested the footage at this time. So if it is unclear to the court, well, it's unclear to all of us. So how has this not been cleared up? In response, CPD gave state police the video from the main driveway side exterior sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Instead, he placed it in his case file. This footage shows the exterior of the sallyport when the defendant's vehicle was brought into the CPD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in dispute in this case, cannot be discerned. Then, about almost a half a year later, so February 1st, 2024, Proctor testified before a federal grand jury, investigating the investigation into O'Keefe's death. And then they're blurring out what was said at the grand jury because that's secret society. And they always do that, so that's normal. Next. 3 months later, on April 4th, 2024, ADA Adam Lally, who now is just sucking his own dick and keeping very quiet while he sits next to Hanky and plays with his panky. ADA Adam, excuse me, sorry about that. ADA Adam Lally received Proctor's federal grand jury testimony. After reading Proctor's testimony, Lally said, wow, I'm going to go ask that trooper if he was in possession of said video footage referenced herein. In response, Proctor gave Lally the sallyport front wall camera footage provided to Proctor in February of 2022, but not the main driveway side exterior sallyport footage provided to Proctor in June. So he, for the first time, Proctor gives the February. Okay, this is her story, but doesn't give him the one that he got in June. Lally immediately turned over the sallyport front wall camera footage to the defense, along with footage from the CPD main driveway showing the SUV on the flatbed. It is unclear to the court where the CPD main driveway footage came from. Yeah, exactly. The CPD main drive camera appears to show a different view than the main driveway side exterior camera. The recording from that camera remained in Trooper Proctor's file. This is her reviewing all this crap. And she's over here like, well, where did this come from? All right. What, if any? Let's see what we got here. Olivia says, it sounds like they are making Proctor the fall guy for all the mistakes. Yeah, seems like Proctor had a little talking, and he's like, listen, we got to put it all on you, and we're going to take care of you in the end here, okay? Don't worry, just patting him up. So again, Lally being the amazing prosecutor, he just totally turns us over so quick. Lally then immediately turned over the sallyport. Okay, great. None of this footage contained a view of the back of the defendant's SUV. Next, on April 10th, 2024, Lally, he filed a certificate of compliance indicating that to the best of his knowledge and the Commonwealth's knowledge, and after reasonably inquiring and doing his checks and balances, that he made every item available through discovery. When defense counsel reviewed the sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised an issue to the court at a hearing on April 12th, 2024, so just days before that last trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated. Why isn't there a footnote there to speak on that, to speak on this fact? Why isn't there a footer there to say, what did you find out about that? Absolute fucking horseshit that there's no footer there. Okay, so is it motion activated? Okay, because it's not. Trial began on April 16th, 2024. with the first day of evidence on April 29th. On April 17th, Lally received footage of the sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the sallyport on the relevant date. Now, this is what's interesting that doesn't come up, is the reason that this happens, supposedly, and what the Commonwealth alluded to, is that Chief Rafferty heard Yannetti speak about this. Okay, so then she went searching because she's like, wait a second, we had that. Like, I know I've seen that before. No mention to that up here. Do you see Chief Rafferty's name anywhere here? Very fucking telling to me. So on April 23rd, 2024, Lally, again, he provided the sallyport interior back wall footage to the defense. How did he get it? Like, no, like this woman is just leaving out critical points of like wild. There should be a footer there. Okay. The images contained in this footage were inverted. State Police Sergeant Buchanan testified on June 5th and 6th of 2024. During his direct examination, Lally showed the inverted sallyport interior back wall footage in open court. Because the video was inverted, what appeared on screen as the right side of the vehicle was in fact the left side and vice versa. The direct testimony did not alert the jury that the video was inverted. On cross-examination, however, defense counsel questioned Buchanan extensively about the inverted video. Now, something that I don't appreciate here is I put this when question mark because give me a date here, sister. The CPD began a review of other video surveillance footage in an attempt to explain the inverted image and to respond to allegations that it had deliberately manipulated the recording. Okay, no date. We have dates up here. No date here. And no footnote. As part of this process, oh, here we go. Now we're going to include her because it's after the trial. As part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallway and the parking lot of the CPD in the early morning hours of January 29, 2022, prior to O'Keefe being discovered in the snow. The rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m., holding a phone near his face. I about died. You guys, this is why I think she should go bench trial. And I'll tell you why. Because here to Bev, you're going to find out that this is not him holding this phone close to his face is not indicative of him being on the phone. It's really important. Like that video evidence wasn't good enough to show that he was on the phone making a call. Okay. So if that's not definitive enough for Bev, because wait till you see what she says. In September of 2024, see, like there's no date here when this took place, right? But now it jumps all the way to September 2024. State or Special Prosecutor Brennan joins the prosecution team. Woo-wee! Yeah. On October 10th, 2024, he provided the rear lot cruiser footage along with other surveillance video. This is why nobody would touch the case. By the way, this is why nobody in their department would touch this case. I'm not going down for this shit. Fuck that. Bring in some schmuck. Okay. So, Hank turns it over. Okay, he turns it over. Again, no footers there. Now, on November 8th, we got a date. Look at that. Another date. The defense emailed Special Prosecutor Brennan requesting all raw video footage from the CPD, which shall include but is not limited to all the cameras capturing the interior of the CPD and exterior of the CPD, including all the parking areas, entrances, exits, and garage between. Special Prosecutor Brennan responded that he would request that the CPD collect and produce all footage responsive to the request. Thereafter, Brennan asked all associated law enforcement to go through all files and databases to facilitate a review of any footage. During this process, Brennan came into possession of the main driveway side exterior sallyport footage originally obtained by Proctor in June of 2023, and that previously turned over to the defense. Proctor. On January 28, 2025, the Commonwealth turned over the main driveway side exterior sallyport video to the defense. As noted above, the footage shows the exterior of the sallyport when the defendant's vehicle was brought into the CPD, but according to Sugar Tits, it is poor quality. This is the defense's argument now. The defense's argument is that the defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain CPD surveillance videos in violation of Rule 14, Brady, and the court's preservation order and October 5th, 2022 order on motion to compel discovery. She further contends, meaning the defendant, that the timing and quality of the video that has been produced demonstrates that the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. According to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. This argument is flawed in several respects. So let's find out why Bev thinks that this is flawed. And that's going to be, first, Bev says, first, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. Before the first trial. Now, I went back and saw Turtleboy's shows, and I thought that they were trying to get this video like way before the first trial. Because that's how they uncovered that, like, the police reports were inaccurate with the time of the tow, things like that. So this to me just blew my mind. Next. The February 2nd, 2022 preservation order, as I told you guys, remember, she was going to live and die on this hill, which is the order was required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. See Defendant Exhibit A. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage. And so this was the argument by Hank, is that this is what you asked for. You never said video surveillance from CPD. And Bev said, check, check. Yep. That's right. That's all right. Absolutely right. So again, Bev cites some case law. We're going to move on to, moreover, where the physical evidence described in the preservation order was further defined as including anything present on or near the decedent at the time his body was discovered and anything found at the alleged crime scene. The order cannot reasonably be interpreted as including surveillance footage from the police station. So do you guys see these technicalities? So check. You got to give it up to the prosecution there. Hank went and did his homework, showed, hey, we can get in here, we can slide this in. Next up, the October 5th, 2022 order on the motion to compel discovery also did not require that the Commonwealth to produce any CPD surveillance video to the defense. That order requested and required the prosecution to produce evidence of all crime scene photos. Again, videos taken in connection with this case. And they're talking about, this is where I disagree. But emphasis added. Defendant's Exhibit B at paragraph 4, the CPD was not part of the crime scene, and therefore the order did not compel the production of the CPD videos. Okay. So, again, check to the prosecution. But do you see this little cat? Do you see this game? Okay. This is not the end of the inquiry, however. The absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14. So that was just handling the order part. Now we get into, well, it doesn't matter because this was Brady and you had to disclose it. So the defendant contends that the prosecution should have inquired of the CPD if any footage existed and then produced all footage because she maintains that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence. Assuming, without deciding, that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again here at the second trial. Now, hopefully this time we're a little bit better prepared because we didn't have it until like the last minute. So there's way more preparation here. But basically what Bev is also saying, though, without saying it, she's doing it in a way that basically if Karen Reed was to be found guilty of trial 1, Karen Reed would have gotten a new trial. So I think people are missing that. And that's just really something to sit here and say the Commonwealth was in the wrong. Karen Reed's getting a new trial. So if she would have been found guilty during trial 1, she'd be getting a new trial because of this. In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose to the defendant as investigative materials, video, and audio recordings in the possession, custody, or control of the members of the prosecuting team, the Rule 14 in effect at the relevant time had no such requirement because the rule has changed. Nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether the evidence existed. And so here is your footer here. She drops it. In this regard, the Standing Advisory Committee proposed a revision of Rule 14, which the Supreme Justice Judicial Court adopted. The revised Rule 14, it kind of deviates and says that the prosecutor's duties to inform and inquire, collect and disclose, preserve and notify, and record items that are subject to the rules. So that was something that has changed. She makes a little note of it. Because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Now, that to me is absolutely fucking crazy when the defense is saying that this was tampered with, okay? And they sprinkled the lawn with 47 pieces of taillight. So I cannot believe that Bev wrote that in here. That's fucking crazy. That's just so crazy to me. Until the Commonwealth knew, for example, that the defense's theory included that the law enforcement tampered with the taillight while it was at the sallyport or that Higgins was a proposed third-party culprit, it had no reason to inquire as to whether any relevant video footage existed. You guys, when do you think that this happened? Are you kidding me? When are they going to say that they just knew this? Oh, in the trial? Come on. We had all those pretrial hearings. This is not to say that the Commonwealth had no duty to turn over the sallyport interior back wall footage before the first trial. The prosecution during trial was undoubtedly late. See, she's like, hey, hold on, just so we're clear here. Okay. However, the defendant received the video more than a month before it was submitted into evidence. And because she has advanced no argument as to what, if anything, what, if anything, guys, she uses it. Dude, maybe Lally was trained by Bev here. What, if anything? And she's like, God, look at how good my little student's doing. You know, as to what, if anything, her counsel would have done differently if the disclosure had come earlier. The defendant has not shown she was prejudiced as a result of the late disclosure. Damn. Like, she wild. She wild. Why would she reveal her strategy? I think that'd be a way of like, I'm not going to reveal my strategy. Clearly it affected us. I just disagree with that. I agree. DML says Commonwealth claims the vehicle was the cause of death. Like, yeah, it's the murder weapon. So we've been saying, why would it not be evidence? Well, it is. And I guess, you know, any footage of it being drove or handled by people, you know. So what, if any? What, if any? Love it. Defendant also argues that the rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense should have used to show Higgins perjured himself before a federal grand jury when he testified that he did not call anyone on the night in question. Now, this is where I said, dude, bench trial with these rulings because she's got to fucking keep it up. Watch. Defendant's memorandum at 20. That argument fails for several reasons. First, it is not at all clear how, within the bounds of admissibility evidence, the defendant could introduce evidence of this alleged perjury at her criminal trial. Second, even a cursory review of Higgins's grand jury testimony reveals that he said that blah, 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 blah. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot, holding a phone near his face, does not clearly show, as the defendant represents, the witness speaking to individuals or individual. Dude, there is freaking video evidence of this man having the phone up to his ear, right? Which, what do you do? I mean, that is, when you want to talk about circumstantial evidence, this is circumstantial evidence that he's making a phone call, right? To Bev, it's not clear. That's why I think that she should have a bench trial, because nothing would be clear to Bev. If she's going to go off of this, that is not clear that he is calling somebody, then nothing that would be presented to Bev in this case would be clear that John O'Keefe was on the lawn. Unbelievable. Not Bev for what, if anything. Bev. Storm Dancer, thank you so much. Thank you. Wild. See, defendant's memorandum at 10. Defendant's exhibit K, the clip, federal grand jury. Finally, in this regard, the remedy for non-production of this video clip is not dismissal because the defendant's rights are fully protected by her ability to use it all for all it's worth at the retrial. She's like, dude, Karen, you're going to be able to use this all for what it's worth here at this retrial. And that's what I'm saying is that had Karen Reed been found guilty of this crime, Karen Reed would have gotten a new trial because of this. So it's just funny that nowhere in the document can she just come out and say that, though. But that's what the document basically says, is that if Karen Reed was found guilty of at trial 1, she'd be getting a retry because all's cured because she's having this retrial. Because that's what, it wouldn't be dismissal that Karen Reed would have gotten. It would have been a retry. Okay? And so can the defense write? So can you clarify for the record that Karen Reed would have gotten a retrial and she would have been retried if she was found guilty with any charge in trial 1 because of this? But because it was a mistrial, she doesn't, that's what I would want to see. Can someone like fucking just do that? And even if I just think that Bev, your record sucks. Your record sucks. And that's why I'm over here like, wow, bench trial with this and with these rulings. Because if it's not clear that someone's on the phone when they have a fucking phone to their ear, then it's got to be clear. It's got to not be clear that John O'Keefe died on that lawn at 12:30 when there's no fucking body on that lawn. Bench trial this shit. She will have to say the same fucking thing. It is not clear like the prosecution says. I mean, it's just wild. It's wild, but I would, based off of this, somebody having a phone to their ear, it's not clear that they're making a phone call. With respect to the main driveway side exterior sallyport camera, even if Proctor should have turned it over to Lally prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. To the extent that the defendant contends that the footage could have been used to impeach Buchanan's testimony, she will have that opportunity at the retrial. Again, we're all good here. We're all good. There's a retrial. She's going to be able to do all of that then. Funny how she doesn't talk about the metadata, though, associated with it. There's these pictures that they took at the house. There's no metadata associated with those pictures. So next up here, she says, the defendant also argues that the Commonwealth has violated Rule 14 by failing to preserve all the footage with, metadata. Here it comes. Damn. There is no merit to this argument. The fuck? The defendant did not make any specific request for the original footage with metadata. How else would you request something to be authenticated without metadata? How do you authenticate it? I mean, this is a judge's ruling. This is a kid's ruling. This is a kid who's wrong. God. The defendant did not make any specific requests for the original footage with metadata before the first trial or before it was overwritten. There is nothing in the version of Rule 14 that in effect of the current version that entitles the defendant to the metadata or log files underpinning surveillance footage in the possession of the Commonwealth, and the defendant has not directed this court to any authority suggesting preservation of such a What? I said, wow, we don't need to prove anything to anyone anymore. It is what it is, right? This is is this wild? I thought the only way to prove that, let's just start taking screenshots of shit with no metadata. Hey, it is what it is. Like, here's a screenshot. This is why screenshots aren't like, yeah, right, you're not getting a screenshot in. Well, according to Bev, you can. Because the metadata don't mean dick. It's crazy. Nor has the defendant demonstrated that the metadata would have been exculpatory evidence. Oh my God, the metadata would have shown if it was tampered with. Like, when did someone decide to invert the video? What about the 42 minutes? How is that poof just gone? If it in fact is even if it's motion activated, there's a ton of motion in there. It isn't just poof gone. I mean, this bitch is wild as fuck. Like, this type of stuff, like, wow. So I think that based on this type of a ruling, I think that Karen Reed has no choice. But I mean, she's gotta, like, this just can't stand the way that it is. I think that this truly messes with. Don't you think this would mess with case law down like in the future? Wow. Nor has the defendant demonstrated that the metadata would have been exculpatory evidence. She offers no evidentiary support for her argument that the metadata would confirm her theory that the members of the CPD or state police doctored the footage to prevent jurors from seeing the condition of the defendant's taillight before it was within the custody of law enforcement and from seeing Proctor damage the taillight. I said 42 minutes are missing. There was movement. Why wouldn't it be there? Like, why does the defendant have to, like, there's motion happening. A defendant who seeks relief from the loss of destruction of potentially exculpatory evidence has the initial burden. The 42 missing fucking minutes is that's me meeting my burden. Dumbass. To establish a reasonable possibility based on concrete evidence rather than a what? Fertile imagination. The access to the evidence would have produced evidence favorable to his case. Yes, it would have. And it's the 42 minutes missing that's your push. Like, there's just like nowhere else in this 12-hour, running clock, however many, from 11, nowhere else is there a 42-minute gap. I mean, God, she's just literally, Turtleboy said, I don't suck Karen Reed's dick. Well, Bev clearly is sucking Morrissey's dick here. So, yes, alternative juror added as Karen's new attorney. That is correct. Yes, Victoria George. Her name is Victoria. So I guess she didn't care if her name was out there at all. So bomb move by the defense, Heather says. Yeah. So wait till we get to about this juror shit. You guys, they're talking about VFWs. They're talking about Knights of Columbus. They're talking about the Dedham hangouts of the world. It's just everybody goes to the VFWs for the cheapest drinks in town. Yeah, so let's take a look. Moreover, during cross-examination, Jackson questioned Bukaki extensively about the video being inverted and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the sallyport. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. Okay, check. Awesome. Again, she would be getting a new trial, guys, if she was found guilty. Lastly, as to this claim, to the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the context of the retrial. So, hey, just bring it on up at the retrial and it's all good. We're good. Withholding of exculpatory statements by Jennifer McCabe. Remember the Spig debacle. So on May 7th, During the first trial, the defense produced reciprocal discovery to the Commonwealth regarding the location information of witness Jennifer McCabe's cell phone. The location data showed that on January 30th, 2022, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of January 29, 2022. In anticipation of her trial testimony, the Commonwealth met with McCabe, Lally, ADA, Brian Tully, they were all present. Tully asked McCabe why her cell phone would have been in the area of Lank's home on January 30, 2024. Well, it wasn't on 2024. It was 2022. McCabe said she was with Carrie Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29, 2024. On May 21st, 2024, Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on January 30th, 2022, and she explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house to talk to them. Jackson questioned McCabe as to why she did not report the fact that she had met with one of the first responding officers on the case working for Canton PD, which is conflicted, off the case. See Defendant Exhibit O. He further questioned her on the length of the conversation, who else she talked to at the house, where she was during the conversation, and if she went in the house. During cross-examination, Jackson also questioned McCabe about the details of her discussion with Lally, McLaughlin, and Tully about her trip to Lank's house. She testified that when Tully asked her if she went to Lank's house on January 30th, 2022, at first I said no, I had never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation. On June 18, 2024, after the defense had received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. During the trial, the Commonwealth interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held on to that report, damn it, until after she testified. The interview, the report, and the completion of the report were all done before her testimony. That's the transcript right there. Now, the court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, saying, no, Your Honor, I'm not. That's not my point. And I think the court understands that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you've what? Jackson responded and repeated, I've done the damage that needs to be done on Jennifer McCabe, and stated, I don't need to call her back. Hank did her job. Hank fucking did all of this. And then Bev just used it in her order. Woo! But didn't answer the question about Tully or Lally's actions. It's typical Bev here, okay? But there's Hank doing her job. The defendant's argument. The defendant agrees that in violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given by McCabe to Tully regarding her visit to Lank's house, which the defendant claims she could have used to impeach McCabe. The version of Rule 14 that in effect, she goes about on this rule. That's Well, basically Bev is just living and dying on the hill that, dude, your lawyer said, fuck no, I've already damaged that hoe, okay? And right here, Bev reiterates it and says, the Commonwealth therefore should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having McCabe's statement. Because on cross-examination, Jackson questioned McCabe extensively about what she had told Tully about her visit to Lank's house. why she had not disclosed such events before, and the details of her visit to the house. Moreover, Jackson expressed satisfaction with the damage he believed he had inflicted upon McCabe's credibility. Okay. When he declined the court's invitation to recall McCabe to the witness stand in this manner, Jackson undermined any newfound claim of prejudice based on the later disclosure. So, dude, Bev is just like, Karen, your fucking lawyer's a cocky son of a bitch, and he fucked you. So take that. That's what that means. Again, she says, but of course, once again, the remedy for a violation such as this is not dismissal, especially where, as here, the defendant's rights can be fully protected at the retrial. So again, pointing out that, guess what? Even though I took my shots at Alan Jackson, this would have still gotten her a new trial. So I think this is all just woo. Remedy for discovery violations. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice. Based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. However, even if the defendant were able to show prejudice, the appropriate remedy would not be a dismissal of the charges. So Bev, thinks that Karen Reed did not suffer any prejudice. And I think Bev needs a lobotomy. Cheers to lobotomies. Okay. So, nor has the defendant shown that the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation. How has this not shown that it poisons the entire investigation? Because I think that's exactly what it's done, is it's poisoned the entire investigation. And a stronger deterrent is warranted to prevent repetition of such misconduct. And that too, as Aleshi, I think, said. Anyways, or maybe it was Alan Jackson. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery, which would have aided her case. Just because Alan Jackson's a cocky son of a bitch, yes, it did fuck her. Okay? Can you imagine if Karen Reed had shitty ass fucking public defenders? They would have got their ass handed to them and stuffed so far up their fucking ass that Karen Reed be shitting out discovery still to this day. This is ridiculous. If Karen Reed doesn't have the team that she has, Karen Reed would have been prejudiced like a fuck. She would have been prejudiced. It'd be insane. Ridiculous. Fucking horrible. Horrible. Let's get into the juice. Massachusetts, you fucking juicy cunts. Whoopsies. Let's go. Massachusetts State Police interference with the jury. My favorite part of this is because, you guys, this is like the O.J. Simpson case. It can't get any more wild when you got jurors that are being asked where they were on a night and it's their own time and dime. And were you drinking and out at the VFW or Columbus, Knights of Columbus? What? A month ago? I don't even remember last night. This is crazy. So here, factual background. During trial, 2 issues arose with jurors. Now, the first one occurred on June 14th, 2024, when one juror, Juror A, we'll call her, reported to the court that another juror, we'll call that person Juror B, had made up some comments about the evidence and the defendant. Footer here, 9. The court has omitted identifying information about the jurors. Such information is not necessary for the purposes of this discussion, and of course, the full record is available for the appellate review. This has been done to afford the citizens who served as jurors in this case as much privacy and peace of mind. Okay, thanks, Bev. Now the new juror's like, hey, watch me. Watch me. So the court called Juror B to a sidebar and questioned her. No, we just found out it was a her. Thank you, Bev. And questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concern that the comments had been one-sided and against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during the trial. The court then questioned two other jurors whom Juror A said were sitting close by when Juror B made the comments. Both jurors stated that they had not heard what Juror B said directly, but that Juror A had mentioned it to them. The court then called back Juror B, who denied making any negative comments about the defendant. That's absurd. I did not do such a thing. I've been on this damn jury the whole time. I fucking talk about her. So, the Commonwealth expressed that if the court struck Juror B, it should also strike Juror A. The defense disagreed as to Juror A. The court ultimately decided to dismiss just Juror B from the jury. Now, a couple weeks later, on June 25th, 2024, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving this fucking Juror A. Juror A was just tattling on Juror B. What do you mean another issue with Juror A? A member of the Massachusetts State Police had contacted court security and said that he received information that a juror thought to be Juror A, like how would he know that, was at one of the local posts for the American Legion. Those damn American Legions, every time. Those fucking bastards be ratting you out. Okay? So, at the American Legion, talking about the case, and that there may be a recording of her doing so. There may be. God, you sick. Well, go bring it in here. Go fetch it. At roll call, I said, damn roll call. We got roll calls at the Dedham Police Department. At roll call for the Dedham Police on the morning of June 25th, 2024, a number of officers confirmed. How and when did they confirm? Hey guys, have you guys heard this? Raise your hands. The fuck? They confirmed that they had heard similar things about the juror. Are you insane? You what? How? Were y'all hanging out at the fucking Legion? This is absurd. The court called a sidebar to discuss this new information with attorneys. Defense counsel says they asked for the name of the Massachusetts State Police officer who had received this information. Ready? And the court officer stated that it was Lieutenant Fanning who told me this. And by God, he is up for awards. He is a Purple Heart winner. He is every heart winners. He is every heart winner in America right now. Lieutenant Fanning, he's so decorated over here. Please. Yes, let's talk about that. Lieutenant Fanning. Now, Lieutenant Fanning is a supervisor in the Norfolk County Detectives Unit. During the investigation into O'Keefe's death, he was Proctor's supervisor. He was also one of the recipients of a group text circulating by Proctor that included references to looking for nudes of the defendants. cell phone, as well as a reference to the defendant's counsel's retarded client's sick, because he doesn't know how to put apostrophe, phone. Lana, did you see that the dismissed juror joined the defense team? I sure did. Make it clap back. Make it clap back. This is so crazy. Defendant's Exhibit Q. Defense counsel represents, and for purposes of this motion, the court accepts, that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness at trial. After explaining to the attorneys the situation, the court called Juror A to sidebar. The following exchange occurred. Ready? It has been brought to my attention that you might have been out recently at an American Legion or a Knights of Columbus or someplace like that in Dedham, and that someone has reported that you may have been recorded talking about this case. That's the information I received. What can you tell me about any of that? Juror A. I don't know. What an answer. Excuse me? I would have been like, the fuck? I go out every night. What the fuck are you talking about? When was this? I don't remember. You guys, this is crazy. Now, have you been at an American Legion home? Like a month ago. Okay. At the time, were you at all talking about, not that I remember, no. So I cannot believe this. She says it right here. Not that I remember, no. I mean, can you get any more like, no? She says no, does she not? Ready? Do you remember if people there mentioned to you anything about this case? I was drinking. I don't remember. I'm surprised Bev didn't say, were you driving that night? Take her away in cuffs. She's like, I was drinking. I don't remember. Someone was talking about the case. Like, I think wait, do you mean like were people talking about it in the bar? Like, she's just, I think that juror thought that she was being asked, what were those people talking about in the bar? And I think she's like, I was drinking. I don't remember what they were talking about. Okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. The juror says, okay. Like, you know how people say, like, okay, when like you're talking to them. Actually, Dan Moore's notorious for this. You say something and he's like, okay, like listening to what you're saying. Like he understood what you just said to him. And he says, okay, like verbal cue. I understand what you were saying. That's it. That's what okay means. All right. Could it have happened? I don't know. Okay. I really don't know. Again, what is clear from this is just, what is this? Okay, the further information I have is that this morning, several Dedham police officers said that they heard the same thing. Same thing as what? That people were talking about the case in a fucking elite, like, or that she was talking about the case. You get what I'm saying? Like, what's clear here? Anyways, she says, the court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in the previous issue and requested that the juror be excused. This girl is just nothing but a problem. The defense objected, arguing that the previous incident was unrelated, has nothing to do with this. Focusing on the incident, the court conveyed a concern that the juror did not deny the incident, but rather stated that she had been drinking. Deny what incident, though? I'm still unclear as to what incident this even is. What is this? Reported that you may have been recorded talking about this case. What, to myself? Like, oh, I wonder which way I'm going to vote. I just fucking can't. Produce the goddamn recording or shove it up your fucking ass, Bev. That's what I would have said. Well, I have no idea, but I welcome this recording because I'm a goddamn lawyer. And if you're recording me without my permission, fuck off. You don't have a right to privacy. You're in a public place, bitch. Oh, you're right. Well, I don't even know what to say, but produce the damn receipts. CBS me. Hey. Cheers. Spring break 2025. Live from Dedham. People are taking off their tops at the American Legion. People are just taking their panties and shoving them up Fanning's ass. Come on. Come one, come all. So this is how she gets kicked off the jury. So focusing on this incident, then she just says blah, blah, blah. And then Bev then adds in the VFW if that wasn't enough. She's like, well, let's discuss this. Thereafter, a discussion about Lieutenant Fanning ensued, with the defense counsel suggesting that Fanning and the Massachusetts State Police may be targeting potential jurors for the purpose of trying to get them excluded from the jury, it sounds like. The court allowed defense counsel to make its argument about why the court should not dismiss the juror. See, now everything's coming to me now. If, in fact, the new attorney on Karen Reed's case was a juror who was a lawyer, right? So she's on this case, and I believe that she was probably the source of a ton of information after the trial. Have you talked about the new lawyer joining the defense team? We're getting there. We're still trying to understand why Bev's a CUNT on a Wednesday and not a Tuesday. Cheers. It's spring break over here. Correction, she was an alternate. Oh, so she wasn't the one that got kicked off? How did we even know who the alternates were and when they were? Because with that, did we pick them all at the end there? So everybody was on until, yeah. All right, well, I just want to point out that, so they kind of go back and forth at it, like, who is Fanning to this fucking case? And, dude, I love it. She doesn't say 2 words during the whole trial, but here's ADA, woo, Sarah McLachlan. I will remember you. So here she was. Lieutenant Fanning is the commander of the extensive security operations that this case has required. What occurred is he received the information. He did not investigate. He has no evidence of any crime. If he did investigate or reached out to anyone, that could have been considered an improper influence on a jury, but that's not what happened here. Okay, guys? All right? That's just not what happened. What happened here was he was just reporting it. So the Commonwealth then made its argument regarding why the court should dismiss Juror A. The court then conveyed its decision. I believe there is credible evidence. The fuck out of here. I believe that there is credible evidence that this juror has had conversation about this case. What credible evidence is she talking about, you guys? Nothing was presented to Bev other than she questioned the juror. She didn't deny that she was at the American Legion. How did they know that? And then that's when Alan Jackson's like, yeah, exactly. How did they know that? How do they even know what this broad looks like? That she was a juror. How do they even know which one? Her number. This is insanity. Were they taking pictures of the hoe? Anybody who believes this is full of fucking whoa. Fourth hand hearsay on top of hearsay. But Bev is like, this is freaking credible. Okay, this is beyond credible. But having your phone up to your ear does not mean you're calling someone. What a fucking crock of shit, Bev. You need to take a fucking break. You need to get your ass to the Cape and let somebody hold back your hair, girl. You need to go wild. Okay, you need a night of someone tugging on it. Crazy. Now, not only can Bev not get her credible evidence right, okay, that it happened at the American Legion, she goes ahead and says that it was at the VFW. So fucking credible, huh, Bev, that you can't even keep your fucking ass straight. All right. Right here. She says, who ultimately told us that this juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but I wouldn't be surprised if she remained as a juror if we did hear from somebody who was at the VFW the night after all. Get it, Bev. What, now the VFW? You don't even know where the fuck the broad was. Calling it the VFW. So her fear is that, you know what, if we keep her on, then people are going to call us from the VFW and tell us that this broad is a drunk mess talking about the case. And I just can't have that. Well, she wasn't at the VFW, Bev. She was at the American Legion. So, God, I hope people aren't talking about VFW. But that's how credible your source is. What a dumbass. Just what a dumb. Continue on. Carry on our way. At this point, the sidebar conversations continued about Lieutenant Fanning, though, because there was a hot exchange about that heaping hot fucking lard of a mess. Man, such a lanky fuck. What a lanky fuck. You know, have you guys ever seen Fanning in person? Dude, total pencil dick, lanky motherfucker. Guaranteed. He loves to go to Key West and tries to, I think he may be undercover gay. But all he wanted to do was bang drag queens in Key West. If that doesn't tell you what type of man Lieutenant Fanning is, I don't know what will. I would die if fucking Bev showed up in pigtails one day to fucking... Dude, if Bev shows up one day in pigtails to preside over this case, preside and reside... Can somebody make me an AI picture of Bev in fucking pigtails? The best pigtail AI of Bev Canoni, okay, gets a fucking shout out for days. Send it to me in my email, okay? I want to see that bee in some pigtails. I want, you know, make it pop, man. Oh, shit. You know damn well she's getting her. Who's going to toss my pigtails today? Call up one of those Fanning boys. No, that's the court. There's just one Fanning, honey. Oh, shit. Bev and space buns. Yeah. So, pigtails, dude. Priceless. So yeah, that's where we're at with this case. It's a mess. It's a mess. But Bev is like, I'll be damned. If I'm going to let you talk about my shit like this. So that's where I'm going to end this live here. But let's talk about the... God, we're waiting for 6:31 to drop. Let's see. That's attorney appearance. Victoria B. George, added for defendant Karen Reed. Out of Canton, I believe. The Buffa zone has been, we're just going to party a little bit further down. The Michael Easter Commonwealth, or the memorandum in opposition for the Commonwealth's motion and Lemonie's fucking tits. I'll go over that later. I want to keep them separated here. So what I'll do is I'll probably do Easter and the new attorney. But this is a statement released to me by Victoria George, an alternate juror from Karen Reed's first trial. She is also an attorney and has given me permission to share the statement, which is her reaction to today's hearing, as well as her name. A fair-minded juror who left this, I don't even know. As a lawyer, this reality is something me even more because I remember much of it. It was just a lawsuit and argument. Yeah, here we go. Commonwealth has a duty to protect the rights of defendants, and I for one. Okay. Perhaps the Norfolk County District Attorney's Office should be more focused on remedying the systematic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayer dollars prosecuting a case with so many evidentiary issues that it calls into question whether they are even following their ethical obligations as prosecutors. Woo! Fuck them up, Victoria. I'll see your ass at the fucking Legion, girl. Till next time, let's all party with Victoria. I hope she was the partier. If she's not, I'll be pissed. Find me that partier. I want the juror that got dismissed for partying at the American Legion in Dedham. I want to buy her a night full of fucking drinks. I love it. Peace out, Girl Scouts. Till next time. Thank you so much. The new members. Lana, did you see? Yep. And Storm Dancer, I got you. And pictures. Thank you so much. Peace.